So it's another major day at the Supreme Court. Today is probably one of the biggest days in recent memory because Roe v. Wade has been overturned. Now, I want to just throw this question right to you because a lot of people are having a hard time understanding this Dobbs decision, which overturned Roe. They're assuming that abortion is suddenly illegal throughout the country. There's a lot of misconceptions. Can you tell us what it is that this Dobbs ruling actually does?
Of course. The Dobbs case says what the Supreme Court should have said back in 1973, which is that the United States Constitution doesn't say anything about the issue of abortion. It's simply not a constitutional issue, and the states are free to regulate any way that they want to, as long as it's reasonable. So this isn't going to make abortions illegal in New York or Massachusetts or California. The places that want to protect abortion rights will still do so, but states that don't think it's a good idea to have abortion on demand for no reason can have laws regulating that. It's now purely a state law policy decision.
So you'll have 50 different states with 50 different laws potentially and regulations on abortion. Would that be accurate?
That is possible. There probably won't be 50 different. There'll probably be some little pockets of sets of laws, but some will allow almost any abortion. I'm guessing that a lot of states will allow very early term abortions, but cut it off a few weeks into the pregnancy. You know, the actual law in Dobbs was a 15-week limit. You know, some states will allow exceptions for things like rape and incest. Others will not. Life of the mother, I think, will always be an exception. If the mother is in danger of dying, I don't know that anyone wants to force her to carry the pregnancy and die if that's the choice, the horrific choice that family has to make. So we'll see a bunch of permutations on this, but probably in the end, there'll probably be 5 or 6 different groups of states, you know, clustered around some of these rules.
So it sounds like, and you did say this, but I'm going to reiterate it, that Roe itself was never really constitutional because the reaction that is out there right now from some of the pro-choice groups, NARAL, Planned Parenthood, this notion of, quote, our constitutional right to abortion has been taken away. They're sort of using that language. You would argue, though, that this should have never been a constitutional right or considered one.
Well, yes, and that goes really into the question of, you know, what is the United States Constitution? Is it a written document that has to be interpreted and applied, or is it whatever the United States Supreme Court says? And those who fall into the camp that the text doesn't really matter, that the court can do justice, the court can empower people, the court can pursue good ends. And by the way, everyone in this debate, from the Roe court to they're all working in good faith. They're all pursuing their vision of the good. There are no evil pro-life or evil pro-choice justices trying to hurt people, right? They're all pursuing their vision of the good. But the group that won in Roe and in Casey in 1992 was basically the Supreme Court saying, doggone it, this ought to be a right. Women should be able to do this, and so we find it to be there even though it's not in the text. The court today has said, our job isn't to make social policy. Our job is to say what's in the document, and the document doesn't protect abortion.
So as we sort of navigate this issue already, because of some comments from Clarence Thomas and some speculation, there are concerns, and there have been throughout all of this, that this ruling will extend into other issues like same-sex marriage. And have you had any thoughts on whether or not that's possible, whether or not that will happen? I was sort of curious on how broad you think the sort of legal arguments underpinning this case could go.
Well, the majority opinion bent over backwards to say we're not reconsidering any of those other cases. Some people will say, "Oh, this will overturn Loving versus Virginia, and we will now have bans on black people marrying white people." Well, I don't know that anyone in this country wants to pass laws against black people marrying white people. It's not going to happen. It's no longer a live issue. To say that that's what we're concerned about is kind of silly. The majority specifically said things like same-sex marriage are not uh, challenged by this decision. This doesn't back off on any of those. Clarence Thomas joined that opinion, but he also wrote a separate occurrence raising a theme that he has raised many, many times. And this gets a little legal wonky, but he doesn't believe in this doctrine of substantive due process, that you find non-textual rights in the provision of the 14th Amendment that says you cannot deny liberty without due process of law. Justice Thomas's view is that those are privileges or immunities of citizenship, which are a different part of the 14th Amendment. And he's made that point many, many times in earlier cases, that he thinks the whole idea of substantive due process is invalid. Now, I'm going to say, from my perspective, the ruling, for example, in Obergefell on same-sex marriage has no more constitutional legs to stand on than did Roe and Casey. It's another one that the document simply doesn't speak to whether states have to redefine marriage to include a non-husband-wife couple. The Supreme Court made it up. Will the court revisit that one? Not necessarily. There's a huge difference, which is in abortion, you're dealing with an innocent person whose life is at stake. And none of these other cases raise nearly that same incentive. So even if the court believes that those cases were wrongly decided, there's a lot less reason for them to feel that they need to go back and change those rulings.
So one final question for you on this, as somebody who's an expert in this arena. People will often say, and I've heard it a lot today after the Dobbs ruling, how could the Supreme Court do this? They're overturning the will of the people. This isn't what the majority of the people want. How do you respond to the function of the Supreme Court and what it's intended to do when people give those sorts of critiques?
Well, it's not the job of the Supreme Court to respond to the will of the people as expressed in public opinion polls or in people standing outside the court or outside the justices' homes protesting and attempting murder. Their job is to apply the law, including the Constitution as it's written, and there are processes for the people to change that. If enough Americans believe that abortion is a fundamental right, then let's amend the Constitution and put it in there. I don't believe that, but if enough people do, you can put it in the Constitution. Protesting the court is just fundamentally wrong. They're not supposed to be swayed by public opinion. They are supposed to say, here's the law, here's how that law applies to the case in front of us. And if the people say that the court is out of the times because it doesn't support abortion, that's the whole point. Go to the legislature and get them to change the laws, because that's the branch of government that is supposed to be responsive to the will of the people.
It's a system of checks and balances, and I think a lot of people have maybe missed that lesson. Listen, thank you so much again for coming back to talk to us about this case. I'm sure at the trajectory we're going with the way that these court rulings are coming out, we will be talking again very soon.
Well, we got three of the biggest this week, so I think next week has to be at least a little bit calmer than this week was. So, religious liberty, guns, and abortion all in 1 week. It's been pretty crazy.
It has been. Well, thank you so much for your time.
My pleasure, Billy. Hope to talk to you again soon.